Start. Even the due execution of the will is not proven on the record, with one attesting witness Mohinder Singh turning hostile and the other attesting witness being given up by the plaintiffs. Stop. Further, the said witness PW3 was cross examined at length by the counsel for the plaintiffs. However, nothing fruitful could be elicited. Stop. Since the will is not provided by the attesting witnesses, it does not meet the requirements of law. Stop. Counsel for the plaintiff appellant contended that the will should be taken to having been proved as the scribe and the registrar had deposed in support of its due execution. Stop. This argument is being noticed to be rejected. Stop. To be an attesting witness, it is essential that the witness should have put his signature animo attestandi, that is, for the purpose of attesting that he has seen the executant sign or has received from him a personal acknowledgement of his signature. Stop. If a person puts his signature on the document for some other purpose, example, to certify that he is a scribe or an identifier or a registering officer, he is not an attesting witness. Stop. The suspicious circumstances surrounding the will have not been satisfactorily explained by the plaintiff appellant. Stop. When there are suspicious circumstances regarding the execution of the will, the onus is also on the propounder to explain them to the satisfaction of the court, and only when such responsibility is discharged, the court would accept the will is genuine. Stop. Even where there are no such pleas but circumstances give rise to doubt, it is on the propounder to satisfy the conscience of the court. Stop. Suspicious circumstances arise due to several reasons, such as with regard to genuineness of the signature of the testator, the conditions of the testator's mind, the dispositions made in the will being unnatural, improbable, or unfair in the light of relevant circumstances, or there might be other indications in the will to show that the testator's mind was not free. Stop. In such a case, the court would naturally expect that all legitimate suspicion should be completely removed before the document is accepted as the last will of the testator. Stop. The aforesaid view is taken by us in consonance with the decision of this court in Shashi Kumar Banerjee versus Subodh Kumar Banerjee and Pushwathi versus Chandra Raja. Stop. In Jaswant Kaur versus Amrit Kaur, it was held that stop. In cases where the execution of a will is shrouded in suspicion, its proof ceases to be a simple between the plaintiff and the defendant. Stop. What generally is an advisory proceeding becomes in such cases a matter of the court's conscience, and then the true question which arises for consideration is whether the evidence led by the propounder of the will is such as to satisfy the conscience of the court that the will was duly executed by the testator. Stop. It is impossible to reach such satisfaction unless the party which sets up the will offers a cogent and convincing explanation of the suspicious circumstances surrounding the making of the will. Stop.